are recording.
Hi, everyone. Thanks for being here. We're going to give it just a couple minutes to let everyone walk in the door. We're really glad that you joined us today. All right, let's get started. So welcome everybody. Thanks for being here. My name is Emily Barony and you're in a webinar hosted by the Economic Development Collaborative. And today we'll be getting a California employment law update from attorneys and partners from Fisher Phillips. Really quick, some housekeeping items. Yes, this presentation is being recorded, and yes, we will email it to you after, likely in the next few days, and we will also email you the PowerPoint. If you have any technical issues, please reach out to my team in the chat. You can also submit questions. We're going to use the Q&A feature at the bottom of your screen. And I just want to remind you all that EDC regularly hosts webinars, and you can register on our website, and we're going to go ahead and put that link in the chat. You can also watch all of our previous webinars, including one by today's hosts, Nicole and Hannah, on mitigating risks in the workplace. And with that, I'd like to introduce our experts from Fisher Phillips, Hannah Swice and Nicole Cam.
Thank you. Thank you so much. We're so glad to be back with you guys. Thanks so much for spending your lunch hour with us. We're going to talk today about some of the legislative and case law updates that have gone down in California over the past year. And what a year it has been. You know, 2020 will definitely go down in history. And there's always a lot going on in employment law. But this year was really, it set a new standard. It kind of took things to a different level with what we'd have to go through with COVID, and then with the legislature, and then now implementing, and now rounding out the end of the year is usually when we sit down and we compile all the statutes that were passed, all the cases that came down, and what changes employers have to implement and be aware of heading into the new year. So in terms of this year, as I mentioned, it's definitely a different type of scenario. The legislature actually recessed for several months earlier in the year once the pandemic started. So we've had a shortened time to hear bills, and there are fewer bills than we normally have. But of those bills, there are quite a few with a significant impact on employers in California. We waited throughout the month of September for the governor to finalize and sign the bills that were going to be passed. And we've since been digesting, implementing, drafting new policies, updating our templates and our records so that we can work with employers as they go forward into the new year. And actually some are already in effect. Some were urgency legislation that went in effect either immediately or shortly after they were signed. So in terms of California, we've had not only bills passed through the legislature, but the governor issued several executive orders over the past period of time, many relating to COVID-19, supplemental paid sick leave for certain workers, a workers' compensation presumption, and some of those executive orders were actually codified by the legislature as a result of the process. Many local governments also passed local ordinances, sick leave requirements, other employment requirements, whether it's testing, social distancing, requirements about temperature taking. So it's very important for employers to be aware of what the local requirements are, as well as the state and the federal. And that's kind of the puzzle of being an employer in California, is really keeping your eye on all the levels of requirements. And generally what applies is the rule or the law of the location where the employee is performing work. So if you now have employees working remotely from home, they might be in a very different location, a different county, a different city than where they normally work. And the employer has to be aware of what requirements might apply in that city. And that's kind of been another challenge that employers have had to handle, especially we have some employees who are wanting to really work remotely. Maybe they live in Los Angeles and they're going to go stay, go quarantine with their family up in Northern California in the Bay Area or another state. What does that mean for employers? So all those are considerations that employers should have in the back of their head. And we fielded those questions regularly. So heading into the first of the bills, we have a biggie. This is one that was on the table for quite a while. It was something that we had seen coming, and we, as defense attorneys working with employers, we were hoping would not be passed because the impact on the smaller business owner is really going to be quite significant. This bill was something that Governor Newsom had put forward pretty much from the start of his term. It was a priority for him in terms of protected time off and time to be with a family and take care of family members. And so it was pretty certain that if it made it through the legislature, it was going to be signed off on. It is something that the timing is kind of concerning because employers are still grappling with everything having to do with COVID, and then now have this other change that is, again, pretty significant. So this is SB 1383, and it's a Cifra expansion. So what is Cifra? Cifra is the California Family Rights Act, and the current Cifra, it has been in place for quite some time, and it applies to employers with 50 or more employees. So this SB 1383 doesn't go into effect until January 1, but it's absolutely important to be thinking about this now and putting policies in place, putting documents in place, and learning what the obligations are, because once it goes into effect, it's going to be something that employers are going to have to address immediately. So existing Cifra somewhat mirrors the federal FMLA. Some of you may be familiar with the federal FMLA as well, which applies also to employers with 50 or more employees. The current law requires, in order to be an eligible employee, so one consideration is, are you a covered employer? Do you have 50 or more employees? The second consideration is the employee an eligible employee? And to be eligible under the current law, the employee has to have worked for the company for 1 year, has to have worked 1,250 hours in that past year, and has to work at a location where there's 50 or more employees within a 75-mile radius. So if that employee meets those requirements, they are entitled to 12 weeks of job protected leave. So essentially 12 weeks to either take care of themselves if they have a serious health condition, to take care of a family member with a serious health condition, and family member is currently defined as a minor child, a parent, or a spouse, or to bond with a baby. So you'll hear baby bonding leave, and Cifra is currently what is provided for that purpose. So those are the three main purposes currently that employees can take that time off. And the time off can be taken intermittently. It doesn't have to be a block of 12 weeks. You can limit under certain circumstances. For example, for baby bonding, you can require employees to take in 2-week blocks, subject to 2 exceptions. Employers do have to continue any health benefits during the period of the 12-week protected leave. And importantly, they have to guarantee or promise or make some sort of concession to reinstate that employee to the same or a comparable position. So that's why it's job protected. Really, you're holding this employee's job for the 12-week period. And it's also important to remember that in California, once an employee exhausts their Cifra leave, it's not that the obligation on the employer is done. The employer still has a duty to comply with other applicable laws, for example, the federal ADA and the state FEHA, Fair Employment and Housing Act, which requires, if there's the need for continued time off for a disability of the employee, an interactive dialogue, and possibly a reasonable accommodation. So it's very important. Unfortunately, we see quite a bit that employers will have the 12 weeks run, and at the end of that 12 weeks will terminate an employee who might not be able to return to their position, and that can create quite an issue for employers. There's an ongoing obligation to work with that employee. So that's basically what the current Cifra is. The changes to Cifra are this. So currently, I mentioned 50 or more employees. That's a big number. And we've had clients who hover between 48, 49 intentionally to not be subject to Cifra or FMLA. And now that threshold has dropped to 5 or more employees. So that's very, very drastic change. Much smaller employers are going to have to be managing this leave and going to have to be understanding and providing this leave. And, you know, in talking about this internally, there's been certainly big concerns about this. What if you're a small employer and you have one employee going out on baby bonding at the same time that another employee develops a serious health condition and another one has to take time off to care for their family member? You could theoretically be required to provide all 3 employees or more leave at the same time, because Cifra doesn't have a similar undue hardship defense that FEHA or the ADA has. So you could be left with a very skeleton crew there in some situations. It also eliminates the requirement for a certain number of employees to be at a certain location or within a certain radius. So in the past, if an employer had small work sites, let's say they had 50 employees total, but scattered across the state, far from each other. And we've had that with some of our clients. Or maybe they had employees at a certain location were subject, but not at a remote location. Now there's no longer, or there will be no longer starting January 1, a requirement that a certain number of employees be within a certain radius. Basically, if you meet the requirement, if you've been with the company for a year and you've worked the 1,250 hours, then you are an eligible employee entitled to leave. The bill also expands the definition of family members. So individuals for whom an employee can take time off to care for if they have a serious health condition. I mentioned that in the past it was minor children, parents, and spouses. We always threw in registered domestic partner because in California that is a protected category, but it was not express. Now it's expressed to include domestic partners, and it doesn't say registered domestic partner, it just says domestic partner, adult children, so any child over 18, child of a domestic partner, sibling, grandparent, and grandchildren. So a much broader definition of who an employee can take time off to care for if that individual has a serious health condition. And that creates a potential stacking issue with FMLA. So remember, FMLA is still 50 or more employees. So if you're under 50, you have to comply with Cifra, but not FMLA. But if you are a larger employer and you're subject to both FMLA and Cifra, theoretically, the employee could be entitled to 24 weeks, 12 weeks, and 12 weeks under each of the leaves, because let's say they took time off to care for their sister with a serious health condition, which is not covered under FMLA. They will not have exhausted their FMLA leave and would still be entitled to 12 weeks under FMLA to, for example, bond with a baby or take care of themselves if they had a serious health condition. So it can create quite an issue and quite a bit of protected time off. And that's why it's really important for employers to have an understanding of these leaves and how they interact with each other, when they run concurrent, when they might be consecutive, and what all the criteria are under each. There's 2 other big changes for Cifra. One is that it eliminates the 2 employees at same employer rule. And what that means is that an employer used to be able to limit the amount of baby bonding time if both parents were employed by the same employer to a total of 12 weeks. Now each employee is entitled to 12 weeks. So they can run consecutive, they can run concurrent, there's different ways that they can make it. They can possibly do intermittent, but each employee is individually entitled to their 12-week total. And there used to be a exemption or a kind of a carve out for key employees for the guaranteed right to reinstatement for the top 10% earners of salaried employees. And that is no longer at play. So you can't have that carve out. It was very narrowly interpreted and not often used, but it's not a defense that employers can lean on anymore. The other category of time off that was provided under Cifra is time off for military exigency leave. Again, pretty narrow. We don't see it come up very often. But if an employee's family member was called to active duty, they can use Cifra leave for that time as well. So if their family member was the primary caregiver and now they've been called to duty, and they need to take care of a family or whatever the situation is, they're entitled to use the Cfra leave for that purpose. It's very, very important to document this, to have both the dialogue with employees documented and to start the clock running on Cfra. And the statute requires actually the employer guarantee in writing that right to reinstatement to the same or comparable position in order for it to trigger the Cfra requirement. And so when you have that letter to your employee, you need to weave that language in there to ensure that you've started the clock running and that they can't then claim down the road after taking 12 weeks, well, actually, this didn't qualify as my Cfra leave. Now I want to take my protected time off. So documentation is very important. You also want to document the continued benefits, but the employee has to continue to pay their portion of any premium. You want to document any expected return date, certainly making sure that you have medical certification to support this. That would be for the serious health condition, and there's other language that you want to work into that. We're in the process internally of revising our policies and creating a packet, including the forms and the template and the checklist that employers want to have. So if anybody needs to discuss that at any point, we're happy to do that. And this is really a great time to revisit your employee handbook or any of your policies. If you don't have an employee handbook, we recommend at a minimum what we call an employment policies memo, which has the critical, essential policies that employers want to have in writing, including at-will employment, a harassment policy, policies about timekeeping and overtime and breaks and paid sick leave. Those are ones that employers, regardless of how big or small you are, you need to have in writing. And this is now one, if you have 5 or more, that we're going to add to that memo. 2 last points. One is there was, starting in 2018, there was a leave called new parent leave. It was for employers between 20 and 49 employees. Employees could take time off to bond with their baby. That has been repealed in view of this expansion. And then lastly, there's been an implementation of a mediation program through the Department of Fair Employment and Housing for smaller employers between 5 and 19 employees, that if there's a complaint that Cfra was not properly provided or there was retaliation or something along those lines, the employer can require that the employee go through the mediation process internally before they bring a civil claim. And we've gotten a lot of questions on this. Just a couple of the common ones that we've gotten are, does the employer have to have 5 employees in California? And the answer is no. 5 employees in the United States, even if you only have 1 in California or vice versa. If you have 1 in Arizona, but for here you have 5 employees, the 1 in Arizona is not entitled to Cfra leave, but the ones in California are. And then is COVID a serious health condition that would trigger Cfra leave? And the answer is probably, but it depends on the facts. It depends on how severe. It depends on whether the employee meets that requirement of the serious health condition, which does have a definition. But it's certainly something to keep on the radar as you're going through this process.
So yeah, so this is a really big one, Nicole. And I do, I think there's going to be a lot of questions. I do see one question I think maybe we want to address now is whether or not this expansion and this particular leave that you're talking about is paid. So that was
very good question. Thank you for bringing that up. Very good question. So the employer does not have to pay. The employee may be entitled to either SDI or paid family leave through the state. So the employer does have to provide information about potential state benefits that they may be entitled to. And then under different circumstances, the employee can request or the employer can require use of any sick leave or vacation during the time off. But the employer doesn't have to separately pay out of pocket, but the employee may be entitled to some state benefit that may partially compensate them during the period.
Great. So, and just one more quick one was, does this law apply to freelancers or independent contractors?
Good question also. So this is for employees. Employers just want to be careful if they are unintentionally misclassifying their workers as independent contractors, they could be covered, even though they say, well, we have 5 independent contractors, we don't have 5 employees. If those contractors are potentially misclassified, which we're going to talk about, then arguably the person would be entitled to Cifra.
Great. So yeah, that's a big one, updating policies, all of that. So this year, as you've mentioned, Nicole, has been a really big year, particularly with the new laws. And I think, one of the big things we saw this year is the fact that many of these new laws have gone into effect immediately rather than just waiting until January 1. And so this one, which a lot of us have heard about, through the executive order that was issued earlier this year. Now we have it codified through SB 1159, which is the Workers' Compensation Presumption. So this really establishes a workers' compensation presumption that applies to most employers in the state of California that have a COVID-19 outbreak. And this is in effect. It went into effect as of September 17th of this year and runs through January 1st of 2023. So this means that a lot more of these COVID-19 illnesses can potentially be covered by workers' compensation. So really, by way of background, in California, workers' compensation, as you know, really the employee has to prove something that this was related to it, the employee's employment. However, in May, when Governor Newsom enacted the executive order creating this workers' compensation presumption, essentially turned this analysis around. So now put the burden on the employer and really changed the way this presumption works, right? So now they're presumed to have contracted it from work rather than having to prove that they did so. So the executive order expired on July 5th of 2020. And, when there was all of this going on, this was one of the first things to really go forward. There were 3 bills. This is the bill that won out and kind of got codified. So what does this bill do and what does this new law do? So it codifies this executive order. It creates a rebuttable presumption also for first responders and healthcare workers. It also creates a rebuttable presumption when there is an outbreak in the workplace. And so this applies to California employers, again, similar to the Cifra. It's for employers that have 5 or more employees. And this outbreak analysis, as you'll see, is a little bit complicated. So it's if an employee gets COVID-19 while there's an outbreak. So that's the key. And then I'll go through further kind of what, an outbreak means in this context. So here it establishes a rebuttable presumption for certain employees who test positive or have been diagnosed with COVID-19 within 14 days after the employee performed work at the employee's place of employment at the employer's discretion. The employee's confirmed COVID-19 case must occur during a period of an outbreak at the employee's specific place of employment for the presumption to apply. And so what an outbreak is defined as is if the employer has 100 employees or fewer, then it's 4 employees test positive for COVID-19 within 14 calendar days. If the employer has more than 100 employees, then it's 4% of the number of employees that test positive for COVID-19 within a 14-day period. The place of employment is ordered to close by a public authority due to the risk of infection of COVID-19. And so basically this went into effect and relates back to July 6, 2020 and applies going forward to January 1, 2023. So one thing I'd also like to note here is that this definition of outbreak is different than what we've seen from Governor Newsom's playbook and what we've seen as being defined as what an outbreak is. And then as you'll note when we go into the next section, talking about the notification procedures for COVID-19 cases in the workplace, you'll also notice there's a different definition there. So it's really important to note that this outbreak definition for purposes of workers' compensation is different and unique to this specific law. So that's one thing to know. So next, looking at this rebuttable presumption does not mean you're stuck with the rebuttable presumption, but it does mean you have to work very quickly under the circumstances, because what has also happened out of this new law is that the amount of time in which a carrier has to deny a workers' compensation claim has been shortened from 90 days down to 30 days. So you'll have to act very quickly to kind of gather all evidence and work with the carrier to gather all the evidence, looking at the case to defend against it. And so one of the other items that is big in this particular law are the reporting requirements now imposed on employers, which are in addition to and different than the reporting requirements I'm going to talk about with regard to COVID-19 positive cases in the workplace. So the reporting requirements under SB 1159 are basically the employer that knows or reasonably should know that an employee is tested positive for COVID-19 shall report certain information to workers' compensation. So it's workers' compensation administrator within 3 business days. And they must report an employee has tested positive, the date that the employee tests positive, the specific address or addresses of the employee's place of employment during the 14-day period preceding the positive test. So maybe this employee actually worked multiple places. You would have to note that. The highest number of employees who reported to work in the 45-day period preceding the last day the employee worked at the place of employment. Again, maybe very difficult, but again, important to keep on your radar to track this information. And so this also allows the labor commissioner to impose a $10,000 penalty against an employer who submits any false information. And as I mentioned, it also requires employers to look back and go back to July 6th and see if there's been any positive tests going back to July 6th. And such reporting was supposed to be done within 30 days of the enactment of this law, so should be reported by October 17th. So really looking at this closely, making sure you know what to do if you are up against the situation, because this is already in effect, it's really important. And if you haven't already reported and you need to report, again, this is something we're working with people on and working with employers on complying with. So moving on to AB 685, this is a huge one this year. This is one that goes into effect as of January 1, 2021. And this really was enacted after, we've seen some of these cases where there's been these huge outbreaks. The employer didn't notify the other employees in the workplace, didn't notify others, continued this outbreak. Particularly in meat packing industry, we've seen several really big cases there. So this really imposes some big complex notice requirements for employers. And this applies to public and private employers. No minimum employee threshold here. And you must provide notice. What's big about this one is providing notice within 1 day. So effective as of January 1, 2021, this new law requires public and private California employers to provide detailed notice to employees where there has been COVID-19 exposure in the workplace, and to provide notice to local public health departments for certain outbreaks. Again, this will be where the outbreak is really defined differently. There are some others under this law that you also have to notify in addition to employees. Exposure of COVID-19 in the workplace.
Hannah, could you re-say that? You cut out just for a minute. Could you just
did I?
re-say that last sentence?
Oh, sure, no problem. So this new law requires notice when the employer receives notice of potential exposure of COVID-19 in the workplace. And notice of potential exposure is defined as 4 separate things. So notification from a public health official or licensed medical provider that an employee was exposed to a qualifying individual, and I'll get to that definition next, at the work site. So basically, you receive notice that someone at your work site was exposed to somebody, again, that was tested positive or, has a confirmed case. And you receive that notice through either a public health official or a licensed medical provider. Notice from an employee or their emergency contact that the employee has COVID-19 or a confirmed case, which again, I'll go into that. They're a qualifying individual. And then notification that the testing protocol, so employers that do a lot of testing, they find out through that testing protocol that somebody is positive, or notification from a subcontracted employer that a qualifying individual was on the work site. So if you have some third party coming to your work site, maybe even to drop off a package and stays around for a while or not, that person may have also, potentially exposed your workforce. So a qualifying individual is someone who has a laboratory confirmed case of COVID-19, has a positive COVID-19 diagnosis from a healthcare provider, and that healthcare provider is a licensed healthcare provider. 3, has a COVID-19 related order to isolate from a public health official. And as many of you may know, there are several local quarantine and isolation orders in place. So that's one that would apply here. Or someone has died from COVID-19. That qualifying individual has died from COVID-19. So those definitions are really important in looking at who is a qualifying individual. Did you receive notice? And then if you have, then what you must do next is you must provide notice to employees, employers of a subcontracted employee, or also a union representative if it applies, who were on the premises of the same work site as the qualifying individual within the infectious period, as defined by the State Department of Public Health. And this is important to point out because this definition can change, and we've seen it change. So that's really key here. So between now and January 1st, this definition may change. And they have been exposed to COVID-19. So this definition is broad, and it really requires the employer to give notice. And again, like I said, in one day, you must provide this notice, and it must be written. So you must have this written notice ready, and we have this written notice provided already, and we have templates prepared. The work site is defined as a building, store, facility, agricultural field, or other location where a worker worked during the infectious period. So that's a very large, amount of people could be in a building, occupied by the employer. But it doesn't apply if the individual did not enter the particular floor of the building. So again, looking at that closely, the notice must be provided in a manner that the employer would normally use to communicate employment-related information. So it can be via text message or email, but it should be reasonably anticipated to be received within the 1-day period. The notice shall be both in English and the language understood by the majority of employees. For employees who may have been exposed, they must be provided information regarding COVID-19 related benefits to which the employee may be entitled under applicable federal, state, or local laws. This includes, but is not limited to, workers' compensation and options for state mandated leave, supplemental sick leave, or negotiated leave provisions. And it also must include anti-retaliation and anti-discrimination protections for the employee. So this language is very broad, and we don't have further guidance as to what exact documents satisfy this specific area. So that's one other item to look out for between now and January 1st. We hope to get some further clarity on that point. Disinfection and safety plan. The notice must also include the disinfection and safety plan that the employer plans to implement and complete per the guidelines of the CDC. The notice to the exclusive representative, the union representative, must contain the same information that is required in an incident report to Cal OSHA, Form 300. So that is a unique requirement there. There are some exemptions for healthcare facilities. And as I mentioned, the outbreak notice under this particular law is different than the definition from SB 1159. The number of cases that meets the definition of COVID-19 outbreak as defined by the State Department of Public Health, which is currently 3 laboratory confirmed cases among workers who live in different households within a 2-week period. So as you can see, that's different. It's 3 people instead of 4. The employer must also provide notice within 48 hours to the local public health agency. And this notice must include the names, numbers, occupation, and work site of the employees, and the business address and NAICS code of the work site. An employer that has such an outbreak must also notify the local public health department of any subsequent laboratory confirmed cases of COVID-19 at the workplace. So even if it's, one subsequent case, must keep them informed. So that's another big one there. One issue with this law is that the number of COVID-19 outbreaks will also be publicly available now. The new law, this particular requirement doesn't seem to make a lot of sense from a timing standpoint. By the time, an employer were to submit this information to the public health department, the outbreak will have gone away by then. However, this information remains on the website and will be available, which can potentially affect businesses. And so, this is one of the drawbacks of this law. And also, Cal OSHA already has the authority to shut down places of employment under certain circumstances, but this specifically provides further enforcement of that.
Hannah,
so, yes?
There are a couple questions that might be relevant if it's a good time.
Yeah, sure.
Okay. So the first one, you had mentioned that there is a little bit of a distinction for health facilities. So the question is, do the laws differ if the employee is in the medical field and this question is a little bit different, and is considered essential? So one, maybe if you want to point out the distinction for health facilities under these bills, and then 2, maybe talk about if an employee is considered an essential worker, which is something that we've certainly talked about quite a bit, and is not necessarily part of the notice requirement, but if you want to just touch on that.
Oh yeah, sure, definitely. So yeah, so I just quickly went through that one there, just in case, I didn't know how many people it applied to. So the written notice requirement does not apply to the health facility as defined in section 1250 of the Health and Safety Code. However, in a subsequent letter to the Journal, we now have further guidance that the legislative intent, though, was also intended to exempt additional health facilities that are defined elsewhere, but are already required to report workplace COVID-19 exposure and cases to the State Department of Public Health and other local health departments. So the new law does not apply to employees who, as part of their duties, also conduct testing or screening, provide direct patient care or treatment to individuals who are exposed to or test positive for COVID-19, unless the qualifying individual is an employee at the same work site. So that's the full extent of that exemption there. And we could go into it further to look at specific circumstances if needed.
Perfect.
And then with regard to the critical infrastructure, so I think that's actually a very important point here. So we've created template notices here under all these different scenarios. One additional, consideration is, are you an essential business? And, does this particular employee fall within the critical infrastructure, right? So there are some different requirements as we've seen under the CDC guidelines. And, again, when we have this patchwork of COVID-19 guidance coming from state and federal, there have been some gray areas with regard to that. However, again, we have also addressed that in the notice templates that we've prepared, because there's some, more lenient requirements there for allowing certain employees that may have been exposed to continue to work rather than mandating that they quarantine. So again, it's not completely risk-free, but we would be happy to discuss that further offline.
Perfect. Okay, so just in keeping our eye on the time, we'll move on, but we'll certainly try to leave time for additional questions at the end. And if for some reason we're not able to get to your question, please still feel free to reach out to us directly, and we're happy to follow up with you.
Thank you.
Okay. So getting off COVID for just a minute, this goes back to just an employment-related bill that was passed and signed into law. There are quite a few leaves of absence that apply to California workers. So we talked about Cifra, which is now going to cover all employees of employers with 5 or more. Pregnancy disability leave also applies if an employer has 5 or more employees. There's time off for voting, which is super relevant right now. There's time off to attend a trial or some sort of judicial proceeding, time off for everything from engaging in civil air patrol and other volunteer duties, donating bone marrow and organ donation. So it's really important also to be aware of the different leaves, time off to participate in school activities or for school appearance. If a child has had some disciplinary issues, the employee cannot be disciplined or terminated because they need time off for that reason. So one of the existing leaves is time off and accommodation for an employee who's been a victim of domestic violence, sexual assault, and stalking. And that's been in place for quite some time. That applies to all employers. If the employer has 25 or more employees, and that's another thing, that a lot of these leaves are dependent on how big the employer is. Some at 5, some at 10, some at 15, some at 25. And so, it's very important to be aware of how many employees you have to know which leaves apply to you. If you have 25 or more employees, then the leave goes a little bit further and says you have to allow these particular employees time off to seek medical attention, services from a shelter or other program, to seek counseling, and to engage in safety planning. So that's been in place for quite some time. This bill now expands this leave to provide leave for these employees and employees who are victims of crimes that cause physical or mental injury, or employees whose immediate family member passed away as a result of the crime. So those employees are now also entitled to protected time off. The employee cannot be retaliated against or discriminated against, and there should be really no adverse action for the employee taking that time off. The bill does talk about the employer's ability to request documentation, but also to be kind of sensitive to the situation in terms of the timing of the documentation and the substance of the documentation. But this is another area where employers should go into their existing employee handbooks and policies and make these edits to comply with the law going forward effective January 1. And then we go back to AB 5, independent contractors. So this is something we have talked about quite a bit over the past period of time. If those listening can recall back to 2018, we had the Dynamics case, and that was groundbreaking in employment law. That case completely shifted the test for independent contractor status in California. For decades, we had the Borello test, which was a list of factors and a balancing test. So we would make our strongest argument and we would evaluate which way do the scales tilt in terms of the weight of the factors. And it was much more available to make an argument, to make changes to strengthen your argument. And there was certainly a possibility that an employee could be, or a worker could be found to be an employee, but employers could at least put forth a very strong position that this worker was properly classified as an independent contractor if at least the majority of the factors were met. What happened in the Dynamics case is the court said, we are not going to apply that test any longer going forward. And actually some people, it's now being tested now whether Dynamics is retroactive. The test is going to be what's called the ABC test. And the ABC test is 3 essential criteria that must be met in order for that individual to be considered an independent contractor. And the first one talks about control and direction, which is similar to many of the Borrello factors. The second one, which is quite the hurdle, is that the worker cannot be performing services that are in the same course of business as the hiring entity. So if you are if you're a gym and you bring in a trainer, the gym provides fitness services and fitness activities, and the trainer is coming in to perform work in the course and scope of that mission. And so that's going to be, that B prong is going to be a hard hurdle. And then C is that the worker has to be engaged in an independently operating business, providing the same services to others. So it may be the case that the trainer doesn't have, you don't train them, they come to you fully experienced and licensed and have all the criteria and the qualifications necessary. And they have their own business and they provide training at other gyms and maybe privately. But that B prong here would be, in my example, which is just one of many, many examples, would be the issue in terms of qualifying as an independent contractor. So then in 2019, the Dynamics case was codified into AB5, which we've all probably heard way too much about. It went into effect January 1, 2020. And right away there was lawsuits, there were pending bills. I think at one point we were up to 30 plus pending bills to either amend, repeal, or revise AB5. There was pushback from different industries, certainly the gig economy, that's the big one. And over the course of this year, those bills have slowly fallen away, and the remaining bill, AB 2257, was the one that was signed into law. And it was a decent overhaul, but it still creates a situation where employers need to be very conscientious about classifying their workers as independent contractors, need to analyze very closely, see whether the individual could fall into one of the exemptions or exceptions or carve-outs, and if so, properly document, make sure that you're treating that person consistent with not just what's in writing, but what's in practice. So I'm just going to highlight, there's really so much to go over when it comes to AB 2257. I'm going to highlight a couple of the main ones that we've seen come up most often. And then of course, everybody's probably heard that Prop 22 for the gig economy workers did pass. And so that's going to be another shift, another change. And I promise you, this is not the last we'll be hearing about independent contractors. It's going to be an ongoing issue. I've heard rumblings, depending on how the presidential election turns out, there may be something coming from the federal government, some changes on that level. So again, employers really need to keep this kind of on the front burner and take a look at any of their existing relationships with independent contractors. Do they need to be evaluated? Do they need to be reclassified? Do the agreements have to be revised to be consistent with the new current state of the law? This law did go into effect immediately, so it's been in place since September 4th. And some of the key changes to AB5 were now there are 109 exemptions from the ABC test. So there's professional exemptions like doctors and lawyers and different types of professionals, certain professionals, not all professionals. For example, a therapist is not one of the included professionals in that category. And that's kind of created a situation for some of the companies and clients that we worked with. There is a business-to-business exemption. And that's one that we used to have a harder time falling into because there was a requirement that the individual who was retained by the hiring entity, couldn't provide those services to the customers of the hiring entity. So in that example of the gym, we would bring in the trainer, and again, this is just an example, but we would bring in the trainer. The trainer could, if they were training the gym's customers or clients, that would be a deal breaker under the business to business exemption. Now that's been loosened a bit, and we have language that says that if that worker is providing services under their name and regularly contracts with other businesses, they meet that prong, that requirement. Also, if they can show that they contract with others rather than are required to show that, or in fact do, then they meet that requirement. So each time you fall into an exemption, there's often a different set of factors that you need to make sure that the worker is meeting, and again, kind of incorporate into your relevant independent contractor agreement. We've made quite a bit of revisions to our independent contractor agreements based on these different relationships. So they really need to be carefully tailored to the situation. The referral agency service provider exemption is another one that came up quite a bit. We used to have an exhaustive list of who can qualify under this referral agency. And to us, this kind of feels like an Angie's List or a TaskRabbit type relationship. And some of the examples were dog walkers and animal sitters. Picture hanging was one of them. Pool cleaning, those kind of, but it was a very specific list, and we didn't know quite how they came up with this finite list. Now it's examples, so it's including but not limited to, and there are a couple industries, the ones listed here, that were excluded. So we have an including but not limited to, except if you fall into one of these categories, like in-home caregiver, that's come up quite a bit. In-home caregivers should not be independent contractors. Retail, agriculture, transportation. So again, you want to make sure that if you're trying to fall under that carve out, that category, you're meeting the elements that fall under that requirement. There is a lot of exemptions and a lot of lobbying by the music industry. There's quite a bit of language with regard to musicians and studio recording artists and performers. So if anybody falls into that industry or that area, that's something to take a look at. Under the professional exemption, there was a category for fine artists, and that was not defined. And so now we have a definition of that, so that's very helpful. And then lastly, the category for single engagement work, single engagement relationships. So for example, a DJ at a wedding or an MC at a fundraiser, that would be what probably somebody would fall into if they were performing that single engagement. And again, you need to have a tailored independent contractor agreement to that relationship. So again, this is something we could certainly talk quite at length on. If anybody has questions, let us know, and revisit your your independent contractor agreements. Make sure they don't reference employment or any of the other documents that you give to those workers as well.
Yeah, so we've been working a lot on this one, as all these new exemptions have come down and really tailoring or looking back at other agreements. So yeah, another big one this year, and big win for the gig economy yesterday with Prop 22. So just a couple quick additional ones here to point out. There's AB 1947, which is the DLSE retaliation and unlawful discharge. So what has happened with this particular law is that it's extended the statute of limitations for purposes of employees who file a claim with the labor commissioner. So previously they only had 6 months to file the claim, and from the date of the occurrence of the event that they claim was unlawful, retaliation, or discrimination. Now that's been extended to 1 year. There's another one, SB 1384, again related to the labor commissioner. The labor commissioner, as many of you may know, can represent someone in basically when there's an appeal filed, if somebody wins at the lower level, at the labor commissioner, and appeals that to the superior court, the labor commissioner can actually represent an individual in that particular proceeding free of charge if they are, warrant that kind of situation. This extends the labor commissioner's ability to actually represent somebody at an arbitration hearing as well under those same circumstances. And also the notice to compel arbitration must also be served on the DLSU, the labor commissioner. So now moving into the new the new cases.
Yeah, so we just selected a couple cases that we think are important, and they also serve as reminders generally for employers with regard to various areas of employment law that come up most often when it comes to claims. So the first one is the Mcpherson versus EF Intercultural Foundation case. And this case, it had to do with an unlimited vacation policy. Vacation is something in California that should be very carefully drafted in terms of the policy and implemented in terms of the employer. Vacation is treated like wages. And once it's earned, it has to either be used or it has to be paid out. And if an employee separates, that amount of accrued unused vacation must be paid out timely at that time. A couple other things to think about with vacation. So one, this often comes up, it's not required by law. An employer is not required to provide any paid vacation or honestly any unpaid vacation. But if they do provide paid vacation, there are certain requirements. So the first one was what I mentioned, that once it's earned, it has to be used or paid out. An employer can put limitations on their vacation policy. For example, you can say an employee doesn't start accruing vacation until they've been with us 90 days or 6 months or a year, whatever you want it to be. But once they do start accruing, that is theirs. You can dictate and restrict use. So if you don't want employees to take vacation during your busy period, maybe during the holidays, if you're in retail or something along those lines, you can restrict, and you could also require employees to use vacation during certain times. Maybe during the holidays, you shut down and you want employees to use vacation during that period. You do want to give employees notice of that. And for exempt employees, for those salaried exempt employees, you want to be careful about forcing them to, if they take unpaid time off during a particular period of time that's less than a work week. So just keep that in mind. A question that came up quite a bit in about March or April was payout of vacation in the event of a furlough. And if an employer furloughs an employee for longer than a pay period, or even closer, a work week, more conservative, a work week, it does have to be paid out at that time. So that created quite an issue for a lot of our clients. Number one, they were going to bring their employees back, hopefully not too far out in the future, and those employees wanted to have their bank of vacation. Two, it was costly and employers were suffering at the time. And so the cost of paying out that vacation was something to keep in mind. The penalty, if an employer does not pay out vacation timely on separation, is that it's similar to if you don't pay out all wages or overtime, is the employee's wages continue to accrue every day that they're not paid, capped at 30. So that can be quite a bit for certain employees. And one last thing to add about vacation, a PTO policy, a paid time off policy, is treated as vacation for purposes of payout. So if you have a combined paid sick leave and vacation policy under a PTO policy, all that amount has to be paid out. If you have a separate standalone sick leave policy and the policy doesn't provide otherwise, you do not have to pay that amount out on separation. Our preference generally is to have separate policies for that reason, primarily also because compliance with paid sick leave has to be very, very strict and implemented very carefully. And it's easier to do that if you have a standalone compliant policy that's not paid out for sick leave, and then a separate vacation policy that you can have restrictions and you can have different language with regard to earning it. Vacation cannot be required to be used you need to have a reasonable time to use that, and it has to carry over to the following year or be paid out at the end of that year. But you can subject the carryover to a reasonable cap, which is generally at 1.5 to 2 times the accrual rate. So if your employees accrue 40 hours a year, they have to be able to carry over subject to a cap of 60 hours, as an example. In this case, the Mcpherson case, the company had a policy that did not apply, a vacation policy that did not apply to exempt employees. But exempt employees were verbally told to take vacation. They didn't accrue vacation. It would not be paid out on termination, but there was no policy regarding their unlimited, quote unquote, vacation time. And in practice, it really was not unlimited. It really was about a de facto 3 or 4 week vacation policy. And so what the court said, and these employees separated and they were not paid out anything when it came to vacation on separation. And they brought a lawsuit saying that they were owed the vacation and the waiting time penalties I mentioned. So the court said that, and this is the first time the California courts have ever considered this issue, but it held that certain unlimited vacation policies may be compliant, but the one in this case was not. So what the court recommended, just in dicta, it was not the holding itself. So this is still kind of a gray area that we're treading lightly in. But if you're going to have this unlimited vacation policy where you want to try to not pay it out on separation, it must be carefully written in writing. It must clearly provide that vacation is not a form of additional wages, but rather to provide a flexible work schedule. So if the employee doesn't take vacation, maybe they can work a shorter week or shorter days to make up. So a flexible work schedule rather than accrual of paid time off. It has to spell out the rights and obligations of the employee and the employer and the consequences of not scheduling vacation. Hannah, would you move to the next slide? It's right over there. Thank you. And then lastly, it has to be administered in such a way that it doesn't become a de facto use it or lose it policy. And this is going back to the requirement under California law that once an employee accrues that time, it's theirs. It's their pay, it's their wages. They can't be forced to either use it or lose it. That's very common. So these are points to keep in mind for your vacation policy. I highly recommend going back and taking a look at any written vacation policy, making sure that all your PTO policies comply with all paid sick leave requirements, and then considering if you have something that's considered an unlimited vacation policy, that's also compliant.
So I think, again, vacation is always a big one. There's a question that came up, and I think you might want to address this one, is if we give 3 weeks of vacation a year and the employee leaves us in 6 months and they don't take any vacation, do we have to pay the full 3 weeks or just 1.5 weeks since the employee worked 6 months?
Good question. So it's going to depend in part on your policy. You want to have a policy because your policy might say you don't start accruing vacation employee until you've been with us 6 months. And in that case, they would not be entitled to be paid out anything. Your policy also should talk about how vacation is accrued. Is it accrued per pay period, per week, per hour? How do you want employees to accrue? And then based on that, you would look at when they're entitled to start accruing and how much they've accrued at the date of separation. If they haven't used any of that, all that has to be paid out.
So another case that has kind of gone up and down here in California has been this case that was brought against Apple. And it's the Apple we all know and love. And it was a class action that was brought by the employees that worked at the Apple stores and were subject to a bag check policy. So these employees, if they brought items to work that were personal items, again, this was per their policy, voluntary, at the employee's discretion, they could bring these items, which included an iPhone, anything, personal wallet, anything like that, then they'd be subject to a bag search while they left, anytime that they left the store. So for breaks, they would be subject to this bag check. The bag check was not paid time. So these employees were clocking out, taking their bag with them, and having to wait around until a security guard checked their bags. So I won't bore you with the procedural posture of the case as how it worked up and down, but what I can tell you is at the trial court level, Apple did win, saying that this time shouldn't be paid. However, this case was appealed and made its way all the way to the California Supreme Court, and the California Supreme Court answered the question about whether or not this time where they're getting their personal items checked should really be compensable time, meaning should Apple pay for this time that these employees have their bags checked. So the court looked to a lot of different factors. And some of those were that, really aren't these items things that are not maybe necessarily voluntary, such as a wallet or, an iPhone. And they even pointed to a statement that was made by the CEO saying that, having an iPhone is so integral to all of our lives that it's, you couldn't even think about leaving home without it. So, in looking at those kinds of factors with the bag check, and the bag checks could take anywhere from 5 minutes up to 45 minutes of these employees' unpaid time. So when this case was looked at by the California Supreme Court said, this time should be paid. So the case has gone back down. This time must be paid, even if these bags were, brought to work voluntarily per the policy. But this case really does highlight an important point is that, are we having employees do anything that we might consider to be, something that only takes up a small amount of time or, isn't a big deal because it's something that, it's part of our policy, looking at what are we having employees do and is it outside of the time that they're working or off the clock. And so this is a case that really highlights that. And in today's world, when we're talking about COVID, this is an issue that we're seeing and we're already starting to see it. Should employers be paying for time, for example, for taking temperatures and, having someone complete a symptom check? That might take only a small amount of time, but is that being paid? So this case really brings that to the forefront.
Absolutely. Yeah, as Hannah mentioned, we're already seeing lawsuits come in. I just got a class action where that is one of the claims, that the employer didn't pay for the time it took the employee to go through the temperature and symptom check. And that argument, that de minimis argument, is really hard to make in California. It's really not going to be, it's not going to be an easy one to knock out if you're not paying for that time. Okay. So on to the next case. This case talks about a commute time, and commute time is a pretty common question. The general rule is that employees are not entitled to pay for their commute. That's the portal to portal under federal law. And the time that it takes to go to and from work is generally unpaid time. But of course, there are situations where there are exceptions. To every rule, there's an exception to the rule. And in this case, the service technicians who worked on these Konica Minolta printers were required to maintain tools in their car. And there actually was a policy that said you employees should have 25 cubic meters or square feet of storage space in your car. So you need to have a certain kind of car that can hold this amount of tools. And when the court was actually looking at the declarations and the testimony, some of the employees didn't have larger cars. They had smaller cars, and they would have to put down the back seat, or they would have to kind of rearrange things so that they could fit all the tools in their car. Plus, there's a question of whether the employees can use that commute time. Even if you're transporting tools, can you use that commute time for your personal purposes? Can you run an errand? Can you drop your kids off at school? Or is there so much control over that commute time that it becomes paid time? And the court in this case said that essentially there's an issue of fact here that needs to go back down to the trial court to be considered. But if the employee was required to carry tools, so remember required versus optional, because there's other case law that talks about employees opting into a program where they maybe take a company car home because they don't want to go to a central location each day, or opting to keep tools in their car because it's simpler or because it just makes sense for their position versus required. And then 2, that the employee was allowed to use that time, that commute time, effectively for their own purposes. If it was required, not voluntary, and if they could not use that time for their own purposes, like the employee whose car was smaller and did not have any room, one said that he could barely see out of the back window. So they didn't have any room to, for example, drop somebody off on their way into work or something along those lines. Then the court indicated that that time would be subject to the control of the employer and that the employee had to be paid for that time. And as these employees were using their personal vehicles, they had to also be reimbursed for the mileage incurred. So anytime you have an employee using a personal vehicle or any sort of personal item, a cell phone, a laptop, now that so many are working remotely, personal laptop, personal internet, this is a question that's come up quite a bit during COVID, is reasonable reimbursement of use of personal items for business reasons. And we absolutely are seeing litigation on this as well, that an employee had to use their personal printer, had to use their personal laptop, certainly using their personal cell phones to conduct work. Is the company reimbursing the employee at least some reasonable percentage of that use? It's going to be a very big issue. So again, if you have employees who are either using their personal vehicles to transport tools, to make pickups or deliveries, to go to remote locations, there's case law and the authority that talks about employees going to remote locations, like in the construction industry. You might have a job site that's quite far away, or salespeople. These are all considerations as to whether that's paid time and whether the use of the personal vehicle has to be reimbursed.
So this one is a case about pay stubs, and there's several requirements under Labor Code Section 226 that an employer must meet in complying with the pay stub requirements. And one of these requirements is the name. And so that is 226A8 is the particular requirement. And so and we've seen several lawsuits on this. We've seen several class actions under just this particular labor code section. So labor code section 226A or A8 requires, the employer to have the name, the entity name, and address. So basically, there has been several cases, like I'm saying, on this issue. And where it has landed is that the employer, again, it may not have the period or things like that. So if it's a minor alteration, it's okay. However, we always recommend it should just be exactly as the name is. And this case is a good reminder of that, because basically this plaintiff sued their former employer, and the former employer was Countrywide Payroll and HR Solutions. However, on the wage statements, they use CSSG instead of the legal name of the entity. At the lower court level, the court went with the employer and said, that's okay, that's a minor truncation. However, the plaintiff appealed this case, and in the Court of Appeal, they disagreed, and they said, this isn't a minor truncation. In fact, they agreed with the plaintiff's argument, which this wasn't a registered name of that particular employer. And in fact, it corresponded with a different entity of this employer. So it was under Countrywide Staffing Solutions Group. That was what the truncation was. So the appellate court said, sorry, this is a violation of 226A8, and sent it back. So here really highlights how important it is to comply even with these very, nitpicky requirements. It's important to check if you're in compliance with Labor Code Section 226. We're always happy to look at a pay stub and see if you meet all those requirements. So that's a good reminder here.
I'm just going to add one little point on the pay stubs. With the FFCRA leave, the federal emergency paid sick leave and emergency FMLA that's required for employers with less than 500 employees for COVID related reasons, we're recommending a separate line item to account for that on employees' pay stubs when you do provide that paid leave for two purposes, one for record keeping and two for the tax credit, seeking the tax credit. So a little note on pay stub.
Good point. And then there's this case, which is David v. Queen of Valley Medical. It's basically a good reminder about meal and rest breaks, but this one's actually a positive case and a good reminder about why it's important to have good meal and rest break policies and what the employer really did correctly here. So in this particular case, you know, this employer was sued. It was a former nurse employee who brought a wage and hour action against the hospital employer, alleging issues regarding failure to provide meal and rest periods on the basis that they were interrupted, and failure to pay minimum wage because of their rounding policy. However, the employer was actually able to get summary judgment granted in its favor by putting forth its compliant meal and rest break policies and showing that its rounding practice was neutral and compliant. So this really does highlight how important it is for the employer to have good policies. But in addition to those good policies, the employer was also able to show with its records that it was doing what it should be doing. So I think good reminder here why it's important to, you know, have these documents in place and to practice what are in your documents. If faced with a claim, you know, this employer was successful in completely knocking out the entire claim.
If anybody has questions about meal and rest break requirements or policies, let us know, because this is a claim that we see on a daily basis, multiple times a day. And going back to the pay stub, the penalty for failing to provide a proper meal and rest break, so proper means timely before the end of the 5th hour, complete at least 30 minutes, and making sure that the employee takes it at all, because oftentimes it has to be recorded. Oftentimes we'll see time records that do not have a clock in, clock out for meals, or they're not timely, or they're too short. The penalty is an additional hour of pay at the regular rate of compensation. So an additional hour for every day, 1 hour for any missed meal break, 1 hour for any missed rest break. Even if they miss 2 rest breaks, it's just 1 hour per day. Ideally, you actually should be paying penalties every so often, because it shows compliance. It shows that that the employer is monitoring. So we've actually used that as defenses in claims, particularly in class actions or larger matters. And then 2, you want to have that penalty as a separate line item again on the pay stub, so that we can identify when those penalties were paid. I have a client with a class action who paid penalties, but just threw it into the gross and didn't identify which dates. And so it's going to be very hard then to use that as a defense, that anytime the employee complained or anytime we noticed an error with the time records, we did in fact pay the penalty that the employee was entitled to, and they're not entitled to any further penalty.
Yeah, no, and these penalties can really stack up, you know, when you're looking at a bigger period of time. An employee can go back 4 years on these claims. And if you have a couple of employees or multiple, as we've seen, you know, with class actions, is really, really add up. So.
Okay, so just to wrap it up, the California minimum wage is going up on January 1. For larger employers with 26 or more employees, the minimum wage will be $14 an hour. For smaller, 25 or fewer employees, the minimum wage will be $13 an hour. This impacts not only the threshold, the floor that non-exempt employees must be paid. It also affects the salary threshold for salaried exempt employees. So as most of you know, exempt employees have to meet both a duties test and a salary test. The salary test is one of the only black and white things in employment law. And it's based on the state minimum wage, not any local minimum wage. When the state minimum wage goes up, the salary threshold goes up, because the salary is based on 2 times the minimum wage on that salary basis. So therefore, on January 1, any exempt employee of a smaller employer must make $54,080. And that's black and white. If that employee does not make at least that salary on a regular basis without subject to very limited deductions, reductions, we have no argument that they're an exempt employee. For the larger employers, it's going up to $58,240 on an annual basis. So very important to audit your exempt employees, make sure they both meet the salary requirement and the duties. And the duties is usually the sticking point, but definitely something to keep in mind. Also to keep in mind, California, being California, has many local minimum wages. And as I mentioned, it's based generally on where the employee works. Some of the ordinances even talk about an employee that spends 2 or more hours in the location in a week is entitled to the local minimum wage, which 9 times out of 10 is going to be quite a bit higher than the state. We've prepared a chart that I'm happy to send to anybody that would like to. If you would like to send us an email, we'll forward you this chart. This is a state minimum wage. These are each of the areas with local minimum wages, and the highlighted in yellow have a local paid sick leave ordinance, which is also greater than California. So we find this very helpful. We reference it often. This will tell you about any local minimum wages and California state minimum wage and when those amounts go up. So if anybody wants that, please feel free to reach out. Looks like we have about 10 minutes or so to answer some questions. So Emily, if you wanted to pose them.
Thank you so much. And everyone, thank you guys for your participation during this webinar. A couple of you gave us questions that were sort of in the moment questions like, does this apply to independent contractors? And we tried to circle back with you to say, hey, give us a little more context about what your question is specifically. So if you did pose a question in the Q&A, make sure you go and check to see if we asked you to adjust your question a little bit. So thank you, and let's hop in. So now that Prop 22 has passed, how does that affect the rest of the gig economy and independent contractor opportunities in other industries? It seems that it undermines the entire idea of AB 5.
There has been quite a bit of pushback when it comes to AB 5, and Prop 22 is one of them. I mean, so much money was put towards putting that prop forward. The companies were very invested in it, and apparently they were successful. It is narrow. It is limited to those gig economy companies that fall within that category. Other companies are currently not going to be impacted by Prop 22, but as I mentioned, I do not expect this to be the end of the conversation when it comes to independent contractor classification in California and potentially on a national level. So certainly stay tuned for more information on that.
Great, thank you. With California Supreme Court ruling Newsom's actions, specifically ignoring established laws about rights as inappropriate this week, what can we expect to change? Does that make sense to you? Or Virginia, maybe you could give us a little more clarification. You could repost your question with more clarification.
Yeah, I think that's helpful.
Awesome. Okay, thank you so much. And actually, same Jillian, your question, we could use a little more information. Any minimum amount of time at the job, example 90 days. So do us a favor and repost your question with more context around what regulation your question.
If that went to Cifra, remember, to be an eligible employee for Cifra, you have to work for the company for a year and work 1,250 hours within that year. Something to keep in mind is if that employee meets that 12-month requirement, maybe while they're out on leave, for example, if the employee's out on pregnancy disability leave, which there is no minimum, you could have an employee show up and on day one tell you they're pregnant and be entitled to pregnancy disability leave. If while they're out on leave, they meet that 12-month requirement and have worked the 1,250 hours, at that point, they would be eligible for Cifra. So that's something to keep in mind.
Great, thank you. For FFCRA, how is FFCRA leave treated? Can it be stacked?
I think this might be a reference to FMLA, the Federal Medical Leave Act, because I was talking about stacking the two leaves and how sometimes there could be a situation where the employee is able to take Cifra time off that's not going to exhaust their FMLA. And at that point, they would be entitled to 24 weeks rather than the total 12 weeks.
Great. Thank you. Does CFRA apply to part-time employees, and how many part-time employees make a full-time employee?
Great question. Yes, it does apply to part-time employees. The analysis of 5 or more employees, it does not distinguish between part-time or full-time. So if you have 5 part-time employees, you're covered. It's just that those part-time employees would be entitled to a prorated 12 weeks rather than, 12 40-hour weeks. It would be prorated.
Great, thank you. Are employees required to notify their employer that they have COVID?
So there's currently actually no specific requirement in place like the ones we were talking about today in the codified into laws. However, this is a good question because it brings up how important it is also for employers to be clear about their policies and what is required in the workplace and workplace safety when it comes to COVID-19. So, again, all of our workplace kind of, safety policies really do include this, that, if anybody has symptoms or has tested positive, they must, immediately report that.
Great, thank you. So the next question comes from a doctor's office. And the question is, we have one employee that tested positive, everyone else is negative. Do I need to report the case to workers' comp? And the 2 other sort of follow-ups, my employee was not in the office and is isolating when she found out. I don't think we need to report for AB 685. But do we need to report the one employee that tested positive to workers' comp per SB 1159?
Okay. So the way the text reads of SB 1159, it applies to this outbreak analysis that we were discussing. However, I think, again, with regard to whether or not is someone going to bring this as a claim or not, I think it would be a good idea to definitely report a positive case to workers' compensation and discuss it with your carrier.
Great, thank you. So regarding AB 685, what if you work with the public? You must notify customers as well, question.
So yes, this applies to, if you work with the public, again, really the categories of who must be notified is specific in AB 685, and actually customers are not specific in that particular, notification section. However, from the start of COVID, it has been our advice, to really look fact specifically at the situation in which the COVID test or the confirmed case of COVID arises, and if it would be appropriate to alert and notify customers, then we would recommend that. But again, this is a fact-specific analysis, not a requirement under AB 685. So it's a really good question because it's something that should be considered as what other third parties must be notified or we'd recommend to be notified.
Thank you. So my office is located in an office building and there is an outbreak. What do I think this is a hypothetical. What do I do? Who's responsible? That kind of thing. Okay,
so the hypothetical is the office is located in the building and there's an outbreak in the building.
It doesn't specify, so why don't you walk me through, let's assume that my office is in an office building and we have an outbreak. What are my obligations to the other, people in the office or the other?
So again, I think it's really, this is another fact-specific one that depending on the facts. So if you're in an office of an office building, again, that would be an area where we would, again, recommend that you should look to notifying the building management of that particular, outbreak. If it's actually an outbreak, who else do you have to notify? I kind of went through that under the AB 685. However, again, this one really does, again, you have to look to where they were in the building, where did the person go, were they in the elevators, all those kinds of things.
Great, thank you. So we've got 2 questions, and this person says she's a freelancer on a W-2. Can you be a freelancer on a W-2, or would she be classified as an employee?
Yeah, so if she's receiving a W-2, she is a payroll employee. If she's receiving a 1099, then that's one thing you can look at to establish that independent contractor relationship. I'm thinking part of the question was, are any of these laws relevant to a freelancer, to an independent contractor? Certainly, certainly the AB5 topic, the AB 2257 topic, and that also applies to freelancers who are bringing in or having other relationships with independent contractors. So that freelancer may be engaging with other people, and then those people making sure they're properly classified, or potentially that freelancer could be considered to have employees of their own.
Great, thank you. So a follow-up, so this says, I'm a freelancer on a W-2, so let's rework that. So if you receive a W-2, you are classified as an employee. If you receive a 1099, you may be classified as an independent contractor.
Well put.
So, thank you, I am an employer. We are very careful about this. So as a W-2 employee, do I have to take 1 hour break in an 8-hour day, or could I do 30-minute breaks twice per day? Right now, I'm only taking 30-minute total in an 8-hour day, and we'll change that to an hour if the law requires.
Okay. So employees, so there's a difference between exempt employees and non-exempt employees. So remember, we talked about the salary threshold and the duties requirements. Exempt employees are exempt from meal and rest break requirements, penalties, overtime, a lot of the requirements that are in play for non-exempt hourly employees. Technically, you can have a salaried non-exempt employee. We generally do not recommend it. If you have a non-exempt employee, which really it's the presumption under the law that all workers are non-exempt, and it's the burden on the company to prove otherwise, all of your non-exempt hourly employees should be tracking all their time worked on a time card or a time clock, including the start and end of their meal break. The requirements for the meal break just generally are 30 full minutes for every 5-hour work period, and the rest breaks are a 10-minute net paid break for every 4-hour work period, generally taken in the middle of that 4-hour period. So if you have non-exempt employees that are not complying with this, and again, there's a little bit of variation in different industries, but that's the general requirement. Non-exempt employees generally should be sticking with those requirements. There are certain waivers depending on how long the employee works for at least the meal breaks. But again, this is pretty specific, so we'd want to take a case-by-case look at it.
Great, thank you. If there's an employer who is the sole owner of 4 companies in which each have their own tax ID, would we count all employees together or separately for each individual company?
I think really this depends on, we'd have to look closer at additional facts. I mean, just having separate entities is not always, going to save you when we look to joint employer, situations. So that's kind of, behind when we say about an employer, we're usually talking about one entity. However, if somebody can argue some sort of joint employment, and things like that, then you have to take a closer look to see if there would, how many would you have, or, are you operating them together and things like that.
Great, thank you. Can an employer force an employee to take time off work and use their paid time off, and they're an accrual employee at a certain time, such as you must take 1 paid week of your vacation time for Thanksgiving?
Yes, the employer can. You generally want to provide what's considered reasonable notice, which the labor commissioner has interpreted as about 90 days, if possible. I know we're less than 90 days to Thanksgiving, but if you have language in your vacation policy that says something along the lines of the company reserves the right to designate or deny vacation, so to determine when employees take vacation, arguably that's putting the employee on notice, but better idea to send a memo, to circulate a memo 90 days out, and let employees know that we will either be shut down during this time, or you're required to take vacation during this time, and any other terms and conditions.
Great, thank you. On Monday, Superior Court Judge Sarah Heckman tentatively ruled in favor of Assembly Member Kevin Kiley and James Gallagher. Sorry, I don't know any of these people or any of this. If I mispronounce it, sorry. for placing a permanent injunction against Governor Newsom for unilaterally making or changing state laws going forward. She ruled Newsom violated the Constitution during COVID with some of his mandates. If that stands, will some of the COVID employer impact law changes be challenged or possibly reversed?
Yeah, I mean, I think this is definitely not the end of the story here with that. And we've seen challenges throughout. So, again, we'll have to see how this plays out.
Great. Okay. Us business owners, we love when you say wait and see.
It depends.
Thanks a lot.
Yeah, it's like, depends, our favorite way to answer.
Depends. Yeah, thanks. So regarding AB 2257, we have a dentist working for us 2 days per week. He is working for another dentist 3 days per week. Can he be an independent contractor? And also, we would like the minimum wage table. So we will send that out in the follow-up email after this webinar.
Perfect. So for the dentist could fall under one of the carve-out categories, but that doesn't mean that that's the end of the story. You still would then have to meet the Borrello test. So you still need to make sure that that dentist or that professional meets all the other factors of the existing independent contractor analysis. Still recommend to have an agreement in place. It's just going to be an agreement specific to this relationship.
Great, thank you. Can an employer require employees to COVID test regularly? If so, does the employer need to provide the testing kits or testing resources? And I'm going to add to that, if you require it, does that need to be paid time?
Very good point.
Yeah, so yeah, so I think really here again, there's been so much about testing. Can you require testing? Yes. But should you look at what industry you're in? There's testing guidance from the state of California. There's testing guidance from the CDC. Because the limited amount of tests available, they've been kind of moved into tiers as to who gets testing, preference. So there's all those items also to consider. Do we recommend that the employer pay for the time if it's required testing? Absolutely. And so, yeah, so there's all those questions. So again, this one, that's more of a general answer. I would be happy to look at the specifics.
Hannah, is it still, I'm not sure if you mentioned this, is it still the case that the employer cannot conduct an antibody test, but only a test for the virus?
That's correct. So that's also a very good point. So there should not be, any antibody tests, that is not allowed.
Great, thank you. And I want to acknowledge that we're 7 minutes over. That's my fault. I just let the questions get to me. So we still have 45 people on. And we've got 3 questions left. So let's just keep it rolling, and thank you all for sticking around. So if an employee gets COVID, how does one prove it was on the job if we can't prove it was contracted on the job in reference to workers' comp?
Okay, so good question, right? And so if we're talking outside the context of an outbreak, right? Because when we talked about that outbreak context, there's this presumption that it was contracted so long as the person had reported to the work site within the 14-day period. Right? But if we're talking outside of that, what should we do? We should absolutely be investigating the COVID-19, confirmed case, regardless, because we should look into where did they get it. Some employees say, you know what, I've had multiple family members and I believe I got it from one of my family members, and there's been no other cases. So OSHA has provided some guidance in this regard. In May, they provided some kind of questions that you should go ahead and ask in investigating this particular aspect, and also being kind of aware of the privacy rights of an individual. Also, OSHA has good FAQs that are kind of helpful on this point as well. So, that's really kind of how you gather the evidence, is you ask questions, do an investigation like you would otherwise. And then that's kind of how you can help, present evidence that, I think it wasn't actually, gotten, the person wasn't exposed to it here. So that's how.
Great, thank you. Mm-hmm. If I'm implementing employee temperature checks as they arrive to the work site, should I be keeping a log of these temperature checks?
So there is no requirement to have a log. And in fact, you should really think about whether or not you'd want to have a log, because there are specific requirements as to how long you keep it and all of those other things, and confidential information and other things that are triggered with regard to a temperature log. So that's kind of, something to look out for.
So
Yeah, in implementing it, should I be keeping a log? I think it's not required to, and in fact, there's risks in keeping a log. So generally what we recommend is that, if you're taking temperatures, you don't actually keep a log.
Great. So if you are considering keeping a log, you want to be really intentional about why and make sure you're complying in a whole bunch of unknown ways. Awesome. What are employers' options if an essential medical personnel, it's a dermatology practice, refuses to wear a mask, they can't breathe, when their work with patients cannot be accomplished at a 6-foot distance?
So yeah, so this is another, area I think we've seen a lot, Nicole, right? About different accommodations. I think one here is to engage in the interactive process with this one. Okay, you can't wear a mask. Well, are there other kinds of masks that, you might be able to provide, or is there some other way we can go about this, and so I think that's really what to do here. And, I think face shields have been one kind of workaround on this. We've seen this come up. Any other or thoughts?
Yeah, I've absolutely had this come up with different clients, and they can't breathe is different than, do they have an underlying medical condition? Is there a need that truly has to be accommodated versus personal preference? So that's why it's really important to have that dialogue, to document that dialogue, and then to determine whether it's something that can be provided, whether there's an option, an alternative. Maybe they don't work for patients or with patients during this period if there's no protective equipment that will work. So there's lots of different options to explore, but having that dialogue is really key. Last thing I'll throw in there, because I'm sure that this is going to be coming up in the next period of time. Can employers require employees to receive the COVID vaccination? And we actually have a dedicated site, pages on our website, fisherphillips.com, that talk about this topic and FAQs. But the bottom line at this point is, again, you're going to want to consider whether there is any sort of accommodation that might need to be provided for either medical reasons or disability. For religion. Those are the two big ones that have come up and have been addressed on a federal level as well. So as we move forward into that phase of COVID, keep that in mind and make sure that you're staying on top of the laws, because we've got a lot of on-the-spot guidance from different agencies and authorities.
Great, thank you. We've got one more, and then I have one myself, since I have two experts on the line. So everyone who's still here, thanks for being here. If you have more questions, make sure you pop those in the Q&A right now. It appears that employers may be responsible for sharing tracing for others that were at the site and COVID is discovered. If we should not keep a log, then how do we notify everyone who's been on the site and may possibly have been exposed?
So if we're talking about contact tracing is a separate, kind of issue, and it's not the same as a temperature check. So we're talking about symptom checks versus, that they're two separate things. So the contact tracing is really that analysis you do when somebody actually is a confirmed case. You go to that individual and say, who do you think you were in close contact with? Or there's actually apps that can help employers, identify who might have been in that close contact range, as was just recently updated by the CDC as of October 21st, which is, that 6 feet, for 15 minutes within a 24-hour period, within the 48-hour period of the infection. So that's the contact tracing piece of it. And so that is what, is required. And I think you're referring to there is, will we be needing to share that with the local health departments and things like that? So yes, I think in that part of it, that's a little different and absolutely should be documented.
And I think, Hannah, you mentioned this when you were talking about the notice to employees regarding starting effective January 1. Those documents do have to be maintained for at least 3 years. So make sure you're keeping a file of those.
Correct. Very good point.
Great. So our business, we're taking this very seriously. We are very strictly adhering to the most conservative side of all of the rules, regulations, and recommendations. And I'm watching some businesses or nonprofits playing a little fast and loose with the regulations. So do you foresee any potential liability in the future if organizations are not are playing a little loosey-goosey with the regulations?
Yeah, we absolutely do. And as Nicole mentioned, we're already faced with lawsuits alleging COVID violations. So yes, I mean, I think we're facing, you know, for employers out there not following kind of guidance or rules, they're facing potential individual claims. They're facing potential class actions. They're also facing, you know, enforcement by government agencies coming in, shutting them down, you know, again, doing the shaming, you know, kind of stuff. So yeah, there's a lot to really, you know, a lot at stake for not complying.
Agreed.
Great. All right, friends, we have come to the end. So I want, ladies, thank you so much for being here. This was utterly confusing and wonderful, and we appreciate you, and aren't lawyers the best for keeping us out of trouble. So thank you so much for being here. As I mentioned, this is being recorded. You will receive a link and the PowerPoint and all of the other resources that we talked about in a follow-up email coming in the next few days. I also want to give a really brief plug for the Economic Development Collaborative. I'm a business owner just like you guys. I'm an EDC client. This is an incredibly challenging year for all of us, and the EDC offers free business consulting, and it's underwritten by your tax dollars. So you've already paid for it. So cash that check and get support from EDC. We're going to put the contact information in the chat, and we'll also put it in the follow-up email. But this is a really hard time to be in business, and you don't need to do it alone. So please call Alondra at EDC and let's get you some support, because man, it's hard right now, and you just don't have to walk this road alone. So thank you both for being here. Everyone who's still here, we really appreciate you, and we'll let you know when the next webinar is. And have a really good Wednesday. Bye, everyone.
Bye.